In today's video, I want to explain a critical feature which you need to understand, and that is the standard of proof required in an employment situation, civil case, and in a criminal prosecution. There's a critical difference, and it actually comes up fairly frequently in the employment context, where an employee may have a view about something being proven or not proven in the context of the employment relationship. And the standard of proof is a vital thing to understand. So that's what I'm going to have a look at in this video. In law, there's two standards of proof. One is the criminal standard, and the criminal standard is beyond a reasonable doubt. So in order for a prosecutor to bring home a conviction, a criminal conviction, he or she must prove all the elements of the crime have been committed beyond a reasonable doubt. This happens in the district court, circuit court, high court, central criminal court, wherever. If it's a criminal case, and there will be a jury involved if it's a murder or a serious crime, so jury will be involved with rape, murder, manslaughter, that type of crime. But they must be convinced beyond a reasonable doubt. That is the standard. However, that is not the standard when it comes to a civil case or an employment case. The standard of proof in a civil case or an employment case is on the balance of probability. So, inevitably, in the workplace or in a dispute that ends up with the WRC or in a disciplinary hearing, you're going to have probably 2 or 3 different versions of events. Let's just say for a minute, though, that you have 2 versions of events. You have the employer's version and you have the employee's version. There will be a conflict. There will be different stories, different narratives. The standard of proof, however, is on the balance of probability. Therefore, at the WRC or in the labour court or in court in a civil case, the judge or the adjudicator will have to decide the case on the basis of the balance of probability if there's a conflict of evidence. Let me give you an example. Say an employee, a young lady, has been guilty of misconduct in the workplace. That is, she's been guilty in a retail environment of, for example, theft of goods or money from the employer. This employee then is subject to the disciplinary procedure and investigation, disciplinary procedure in the normal way, and ultimately is dismissed for gross misconduct, that is theft. The employer then goes along to the Gardaí, because there's quite a bit of stock involved, and makes a complaint. The Gardaí investigate the case and they prepare a file for the DPP. The DPP, that is the Director of Public Prosecutions, then goes along, looks at the file and decides whether to prosecute or not. The DPP, however, has to be mindful of public resources, taxpayers' resources, and the DPP is not going to pursue a case that has no prospect of success. So he's going to weigh up the evidence and he's going to see if, beyond a reasonable doubt, he can prove the commission of the offence. If he feels he can't prove the offence, in other words, if the evidence is not strong enough, the case won't go ahead and there'll be no prosecution. However, that does not mean that the employee did not take the stock or was not guilty of the misconduct in the workplace. It simply means that the DPP feels that there isn't enough evidence to prosecute on a criminal charge, and the criminal charge, remember, must be proven beyond a reasonable doubt. So let's flash back or move sideways then to, say, the WRC. The WRC, the employee, the lady in question, has brought a claim for example, unfair dismissal or discrimination or something of that nature, and there's going to be a conflict of evidence in the WRC hearing. The employee is going to say, I did not take the stock, I did not take the money, I'm not guilty of the misconduct, and there's no evidence. The employer is going to say, yes, you did, etc., 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 and that's why we fired you. The adjudicator then has to decide the case on the balance of probability. In other words, what was the most likely narrative? What's the most credible series of events? Which version of events, the employer's or the employee's, is most likely to have occurred? And on that basis, the adjudicator will decide the case on the balance of probability, not beyond a reasonable doubt, on the balance of probability. So if the adjudicator finds, for example, that on the balance of probability, the employee in question did in fact take the money and take the goods, that's it. It's a fair dismissal. Employee loses the case, the employer wins the case, and that's it. It's vitally important, though, that you understand that the very fact that the employee can go along to the WRC with a claim for unfair dismissal on the basis that the DPP decided, not the prosecutor, that is not enough to win a claim at the WRC for example, unfair dismissal, because of the difference in the standard of proof required. The standard, remember, in a criminal prosecution is beyond a reasonable doubt. The standard in a civil case or in an employment case is on the balance of probability. You need to be aware of that. And obviously it's useful for an employer as well to understand what is the standard of proof in an employment dispute. In an employment row, it's on the balance of probability. Whose version of events is most likely or more likely, more reasonable. And that is the basis on which the adjudicator or the WRC or the Labour Court will decide an employment hearing. I hope you have found this video useful. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button down below and click on the bell, and you'll be notified every time there's a new video. And thank you for all of your support, your shares, your likes, comments on the videos on YouTube. Keep them coming. Thanks a lot.